I'm Spencer Mazyck, and joining me now is the chair of Baker Hostetler's Antitrust Group, Robert Abrams. He represented a class of dairy farmers across 14 states in settling federal antitrust claims against the Dairy Farmers of America. This final settlement, which was reached in January, totaled $158.6 million. Welcome, Bob. Thank you for joining us today.
Thank you for having me, Spencer.
So, Bob, I say final settlement because haven't there been two other settlements in this antitrust class action that was filed back in 2007?
Yes. Actually, today is the anniversary of the final approval of the first settlement, which was with Dean Foods for $140 million. And last summer, there was a settlement with two other defendants that was for $5 million and changes in the structural and operating conditions as to how those defendants did business in the Southeast. And then, as you said, there is now a preliminary approval of this final settlement with DFA, Dairy Farmers of America, for $158.6 million. But very importantly, that settlement also contains conditions regarding conduct, whereby DFA has agreed to change, I think it's 13 ways it is conducting business and how it treats its members in the Southeast. And I know those conditions were very important to the farmers in the Southeast.
Well, and I want to get to those conditions in just a bit, but this settlement then is more than $300 million. And can you tell us about how many Southeastern dairy farmers were included in the class?
There are approximately 7,000 Southeast dairy farmers. They are the farmers in what the Department of Agriculture puts in as federal milk marketing orders 5 and 7. And they comprise the farmers in about 14 southeastern states.
What were the allegations here? Because I think it's important for people to understand the issues. So what did the plaintiffs allege that the defendants were doing to stifle competition?
Well, we alleged violations of the Federal Antitrust Sherman Act, Sections 1 and 2, a unreasonable restraint of trade, a conspiracy to allocate markets and to fix prices, and a conspiracy to monopolize. To put some, if you will, normal terms on that, we said that two of the key defendants were Dean Foods, the largest food processor in the country, and Dairy Farmers of America, the largest co-op of dairy farmers in the country. And we alleged that they conspired to give DFA the raw milk market in the Southeast, and to give Dean Foods and certain other processors that were co-conspirators the processing market in the Southeast. And at the time we filed the lawsuit, the market that was controlled by DFA's right to supply exclusively all the milk to the processing entities was 90% of the market.
And wasn't there even an allegation that DFA was flooding the Southeast market with raw milk as a way to depress prices?
There is an allegation that DFA was flooding the market. The effect of that was to depress prices. The real focus of the claims, if I may, I like to describe them in terms of a three-legged stool. You might think of it as a milking stool. At least, I'm sorry for the analogy, but
No,
I
it's
always
a great
found
one.
it amusing. And we claim, we alleged, that the chairman of Dean and the then chairman of DFA agreed to this market allocation that I just described. And the way they would accomplish it was as follows. One leg was through full supply agreements. A full supply agreement is a contract between DFA and a processing plant whereby DFA had the exclusive right to sell all of the milk to that processing plant, and the processing plant had the obligation to buy its entire supply from DFA. And the effect of that, of course, is to limit the options of farmers who are either not members of DFA because they choose not to be, or choose to be what we call independent farmers. And it also allows for this cozy relationship between Dean and DFA. And I'm excluding some other processors when I just say Dean, but another defendant, for example, was National Dairy Holdings, a processor that in fact was owned at the time 50% by DFA and then eventually 100% by DFA. And there were named co-conspirators as well.
And Bob, let me ask you, and so then also was it alleged that Dean Foods then stopped buying raw milk from these independent dairy farmers as you've described them?
Terrific, because that gets me to the second leg of my stool, Spencer. Yes, and Dean did that. Dean was buying from over 1,000 independent dairy farmers. But if you're going to get control of the marketplace, as we alleged, you had to deal with these 1,000 independent marketers. Well, the way that was done is Dean and DFA established an organization which was a defendant called Dairy Marketing Services. And Dairy Marketing Service, if a processor was to buy milk from an independent farmer, that farmer was required to sell its milk through Dairy Marketing Services. What the farmers were not told was that DFA controlled the operations of Dairy Marketing Services, including the setting of the price of that milk. So that, in effect, allowed DFA to control the milk of independents. Of course, it had its own members, which then gets us, and I'm sure you're going to ask me this next, so I'll anticipate, to the third leg of the stool. And that relates to another defendant, SMA, Southern Marketing Agency. Because DFA was not the only cooperative in the Southeast, there needed to be a way to get control of the milk marketed through other cooperatives. And through these full supply agreements, of course, the processors were not going to be buying from these other cooperatives. The other cooperatives had milk of its members to sell, and the way they could do that, and the only way they could do that, is to join SMA.
If those allegations are true, I can see how that might stifle competition there. But in reaching a settlement here, you know, in addition to making the monetary payment, you alluded to some conditions that the defendants have agreed to make. Might those conditions actually profoundly impact the dairy market?
Yes. Well, I think the lawsuit itself, as well as the conditions, have profoundly affected the dairy market in the Southeast. And let me tell you why I say that. I just talked about Dairy Marketing Services, one leg of the stool. It was established January 1, 2003. It was dissolved January 1, 2013. That is the beginning of this year. And I would submit that this lawsuit had was a significant reason for that dissolution. SMA was established in April of 2002. There is currently, as I understand it, there are currently resolutions before SMA to dissolve, which are pending, and there's a resolution or a consideration by DFA to withdraw from SMA. So I think that part of the structure of the marketplace changed and did so very positively. The third leg of the stool, the full supply agreements, I told you constituted 90% of the market when we filed the suit. Today, less than 30% of the market is controlled through full supply agreements.
Wow.
Which is a and that's a figure that doesn't concern me as an antitrust lawyer or for the reasons I know about the operation of milk marketing in the Southeast. In addition, DFA, as one of the conditions of this settlement that we were just talking about, agreed to waive the penalty provisions in 2 full supply contracts it currently has with Dean Foods, and agreed not to enter into any further full supply agreements for 4.5 years.
Bob, those are some pretty significant changes. It does sound as though this case has reformed in many ways the milk market in the Southeast.
I truly think it has, and I will tell you that I am perhaps naive in saying this, although I don't think I am, and I certainly hope I am correct. I think the farmers in the Southeast, all of the farmers in the Southeast, the independent farmers and the DFA farmers, will benefit by a strong, appropriately run DFA.
So, Bob, can you tell me, how did you come to represent this class of dairy farmers?
Well, that's kind of, I think of it as an interesting question.
Tell us about it.
I spent the first 38 years of my career at a law firm called Howery and Simon, and grew up as an antitrust lawyer. And the firm decided to represent a group of tobacco farmers. Well, that in an antitrust case, and they were the tobacco farmers are the growers of tobacco. They sell to the tobacco companies, and we represented those farmers against the tobacco companies. The result was a very good result for those tobacco farmers. I was not involved in that lawsuit. After that lawsuit, the tobacco farmers, I found out, a lot of them are also dairy farmers.
Tobacco and dairy.
Right. And they came to us, that is the law firm, and said that they thought things were going on in the Southeast dairy market that were not appropriate. Would we look into it? And the law firm did an investigation, looked into it, and made a decision that a lawsuit should be filed. At that point, the firm came to me and asked me if I would be willing to be lead counsel in that case. Now, I had spent my whole career representing major corporations, and I certainly enjoyed that, and I still do that. But I also thought that this was a solid lawsuit, a lawsuit that should be filed. I was very happy to agree to do it.
And I'm sure that the dairy farmers are very grateful to you for taking the case. I want to switch gears for just a bit, Bob, because I have you here, so I have to ask you about the antitrust enforcement under the Obama administration. Have we seen an increase in the number of enforcement actions in the last 4 years or so?
I think people say there has been an increase. I'm not so sure that's correct. The Obama administration, the Department of Justice, has been very willing to take on high-profile cases, you know, like the AT&T T-Mobile merger, or currently the Anheuser-Busch proposed merger, or the price-fixing case involving Apple and e-books. And by those high-profile cases, I think people get the impression that there is a big increase in enforcement. If you were to actually look at the statistics of proposed mergers, approximately 4% of the proposed mergers were subject to investigation under the Obama administration, compared to 3% under the Bush administration. So I don't think it's a huge increase. Now, I will say that the Obama administration has filed a greater number of criminal antitrust cases than under the Bush administration, although it's about equal to what was done in the 1990s.
Would you say that the Obama administration, though, is more committed to strong competition and a healthy free market economy than the previous administration?
I would say that, yes. I mean, that is my impression. That's what I get from talking with my colleagues and talking with some government enforcers.
And do you think this trend, though, will continue for beyond the administration the next 4 years?
Well, I think there's a plus for that conclusion. I see that, or at least I believe, that the Congress has appropriated relatively more money to the Department of Justice for its enforcement activities. I think it is a good idea that the Department of Justice has brought in experienced antitrust trial lawyers to help it handle certain litigation. I think that is a plus. And I think the people that it has put in charge of the Department of Justice and the Federal Trade Commission are good, solid people who will do the right thing.
So, Bob, before we go, I know that there's probably one other trend that you hope will continue, and that's the fact that your office has doubled, the antitrust team has doubled since 2010. What's behind your growth there?
Well, I will admit that part of that growth was with me. As I say, I went from Howery, and the Howery firm dissolved in March of 2010. And I went with 17 of my colleagues to Baker Hostetler. These colleagues are people who I have actually tried antitrust cases with and complex litigation matters with. We tried class actions while at Howery. And they are terrific lawyers, and they've attracted some additional people to Baker that have since come on board.
Well, Bob, thank you very much for being here to talk to us about this case. It's a very complex case, so we do appreciate your explanation.
Thank you very much for having me, Spencer.
For more information on this or other topics, subscribe to BloombergLaw.com. You can follow us on Facebook and Twitter. Thank you for joining us. Bye, everybody.